Okay, so welcome along everyone to today's webinar on last year's decision by the Queensland Supreme Court of DMS Maritime against Navigators Corporate Underwriters in Limited. I'd like to begin today's presentation by paying our respects to the Gadigal people of the Eora Nation, upon whose lands and waters we work and meet today, and the elders both past, present and emerging. We acknowledge them as the traditional owners and holders of knowledge of the lands upon which we meet today. So it's great to see such a strong level of registration for today's webinar. As a lot of us will know, decisions on the Marine Insurance Act of 1909 do tend to become quite infrequent in Australia. So today's presentation will be a very valuable opportunity for us to hear from those who are involved in this recent decision, which related to a claim for a Navy Armidale class patrol boat, which was undergoing refit in a dry dock on land. So to give you an overview of today's presentation and from the people who are actually involved in running the matter, firstly, Chris Finn, who's a partner at Kennedy's, will provide an overview of the matter and of today's presentation. Proceeding from this basis, Joe Nicholls will then provide an overview of the Armidale class patrol boat project, the fire, and the different parts of the contract. Peter Craney will then go into the nuts and bolts of today's presentation, which will look at the reasoning of the court and how the court went about deciding that the Marine Insurance Act applied to the matter rather than to the Insurance Contracts Act. So it's a very landmark decision in this regard. Finally, Chris Finn will end off today's presentation, and there will be certainly an opportunity for questions at the end. Just a reminder before I hand over to Chris to commence today's presentation is that you can post questions in the chat function, which you'll see on your screen, and we look forward to a very engaging presentation. So I'd now like to hand over to Chris to commence today's presentation. Over to you, Chris.
Thanks very much, Robin, and thank you, Ayala, for the opportunity for myself, Peter, and Joe to present today to your members on this recent interesting case involving certain aspects of the Marine Insurance Act, and in particular the interplay between that piece of legislation and the Insurance Contracts Act. I'll just start by giving a brief overview before we go through the nuts and bolts in more detail. But the case had its genesis in a fire which occurred on board a Navy patrol vessel, the HMAS Bundaberg, back in 2014. That fire occurred whilst the vessel was in dry dock, with repairs being undertaken by a contractor of the plaintiff in the case, DMS Maritime. Ultimately, the decision in the Queensland Supreme Court involves some very interesting issues in the context of marine insurance law and the ICA, some of which had not been previously the subject of any judicial authority. The first and main one was the consideration of the provisions of subsection 9(1) capital A, 1B and 1C of the Insurance Contracts Act relating to the decoupling or disaggregation of provisions or parts of an insurance contract. The second interesting and largely undecided issue was whether or not a ship repairer's liability policy, which was the key aspect of the policy here, which was part of the relevant policy, it was actually a marine insurance contract and therefore subject to the Marine Insurance Act rather than the ICA. We acted for a market of Lloyd's underwriters who subscribed to 50% of a first excess layer policy described as insurance of marine liability. The plaintiff, DMS Maritime, or DMS, was the insured. The policy was a bundled contract of insurance comprising several different sections of cover, which incorporated by reference certain standard form London Marine wordings, and also picking up by reference to conditions in certain sections of an equally bundled underlying primary policy. At the outset of the proceedings, a question arose as to whether our client's excess policy was governed by the ICA or the Marine Insurance Act. DMS contended for the former, whilst our client underwriters for the latter. This was important as our underwriter clients had sought to avoid the excess policy for material non-disclosure. The parties therefore agreed to have the Supreme Court of Queensland determine this as a preliminary issue, given its importance to the disclosure or non-disclosure defences sought to be employed by our client. Generally speaking, as a lot of you know, the ICA is more favourable to the insured in terms of disclosure and non-disclosure defences than the MIA, which favours insurers. But what constitutes a contract of marine insurance is not so straightforward, but for this decision, there was limited authority on whether a ship repairer's liability policy was a marine insurance contract. If the policy was a contract of marine insurance, Section 24 of the MIA would apply. Under that section, the insured's duty to disclose is to all material facts it knows or is deemed to have known. If the policy was a contract of general insurance, then, as people know, Sections 21 and 28 of the ICA would apply. As to non-disclosure under the ICA, under Section 21, an insured is not deemed to know matters for the purpose of the duty of disclosure. That only applies to matters actually known by the insured. Also relevantly, the position of a hypothetical prudent insurer is irrelevant for the purposes of under the ICA. The insured must disclose all matters it knows, being matters that it knows to be relevant to the decision of the insurer whether to accept the risk or whether a reasonable person in the circumstances could be expected to know would be so relevant. And then obviously in the absence of fraud, an insurer of a policy governed by the ICA is not entitled to avoid the policy ab initio, but rather it can reduce its liability to put itself in its place had the non-disclosure not occurred, and that depends on obviously reducing relevant underwriting evidence, especially if it wants to reduce its liability to nil. So from that, it's apparent that the MIA provides a distinctly easier path to a remedy for an insurer arising from non-disclosure. And the evidence obviously needed to be adduced by an insurer to advance a non-disclosure case differs depending on which legislation applies, and that was a key reason why the issue was agreed to be determined on a preliminary basis. Also, where a contract of insurance provides cover for only one kind of risk, the question whether it is governed by the MIA or the ICA gives rise to a question of the characterisation of the contract in its entirety. However, as I alluded to, subsections 9, 1A, 1B and 1C of the ICA provide in effect that a bundled contract of insurance can be disaggregated or split into one or more notional contracts, which allows for the characterisation exercise to be formed at a level other than just at the level of a contract in its entirety. However, no court had previously ruled on the question of whether and in what circumstances Section 9, 1A can be used to isolate part of an integrated or bundled policy. So this is a new issue, and a consideration not completely addressed either by the text of the statute or indeed in the explanatory memorandum is how the grouping of provisions, i.e. the construction of notional contracts, should actually be carried out. So this was the first time a court had to exercise its judicial powers to determine that. So that's a brief overview of the case and the issues that we had to look at and what the court had to look at. I'll just briefly go through a quick agenda and then hand over to Joe Nicholls to run through initial aspects. So that we'll firstly briefly look at the Project C1444, which is in relation to the patrol boat provision. Joe will then look at the fire and the incident and talk through the relevant contract and policies, and then he'll hand over to Peter to talk through the relevant decisions. Firstly, touching briefly on the underlying case involving the DMS and the primary insurer's RSA, and then talk about the decision of the Queensland Supreme Court last year. I should say that also point out that whilst the decision of the Queensland Supreme Court was initially appealed, the matter has since settled between the parties, so it won't be proceeding to an appellate court for further determination on those issues.
Thanks, Chris. I'll now give an overview of the context of the Armidale class patrol boat in naval history, the tendering process, the contract, the Bundaberg vessel, and the insurance policies, the subject of the Supreme Court of Queensland proceedings. Firstly, patrol boats such as the Armidale class have provided an important capability to Australia since 1967. The first, the attack class patrol boats. The attack class was subsequently replaced with the Fremantle class patrol boats from 1980. Plans to replace then the Fremantle class were first given consideration in the early 1990s as the oldest boats approached their designed hull life of 15 years. The decision was made to modernise the Fremantles and extend their hull life to 19 years to bring up to 1999. In 1999, due to the high ongoing maintenance costs, the Fremantle class, compared with the developing new design, it was resolved to commence a replacement patrol boat program known as C1444. Instead of the traditional defence process of specifying detailed requirements, such as the number of vessels of a particular weight, length, and construction, the ACPB tendering strategy followed a performance-based model. Thus, the tender sought a patrol boat system to provide 3,000 days of operational availability of specified performance, with a capacity to surge up to 3,600 days to meet operational contingencies in any 1 year. Unlike previous patrol boat programs, the emphasis was on the capability at sea to meet operational requirements, not on the number of boats purchased. It was left to the tenderers to meet the 3,000-day requirement with a reliable patrol boat force rather than a predetermined number of vessels. A request for the tender to replace the Fremantles was finally released in 2001, and tenderers were evaluated through 2002 and 2003. On the 17th of December 2003, a contract was awarded to Defence Maritime Services Proprietary Limited, DMS, the Armidale class patrol boat, the ACPB, with construction undertaken by Austal Ships at its Henderson Yard in Fremantle, Western Australia. Giving rise to the ACPB contract, which we'll refer to later, the $553 million contract was for the design, construction, and service support of initially 12 boats. However, 2 further vessels were added in 2004. The Armidale class were built to a combined commercial and naval standard with an aluminium hull, and it's fitted with state-of-the-art systems optimized for surveillance patrol response. At 56.8 meters in length and a beam of 9.7 meters, this vessel was propelled by 2 MTU 16V M70 diesel engines, roughly about 2,300 kilowatts each of power, giving the ship a maximum speed of 25 knots. The vessels have an onboard surveillance and communication systems which facilitated its patrol and response capability. The system includes 2 twin radars, a radar warning system, an electro-elliptical detection system for short-range detection. In terms of armament, the fun stuff, the ACPB are equipped with 1 25mm Raphael Typhoon automated cannon and 2 12.7mm machine guns. The cannon has a rate of fire of about 200 rounds per minute. The Armidale have 21 crew and a range of 3,000 nautical miles. The first Armidale class was commissioned in 2005. The last entered service in February 2008. The HMAS Bundaberg was the 9th of the 14 vessels in the fleet, and it was commissioned on the 3rd of March 2007. Slide. As with other vessels of the Armidale class, the Bundaberg has formed part of Operation Resolute, which patrols across Australia's northern waters. The Bundaberg participated in various other exercises during her commission, including exercised Talisman Sabre in June of 2007, which involved boarding an illegal foreign fishing vessel, one overseas deployment in April of 2011 to Vanuatu, and among other notable operations, the HMS Bundaberg facilitated Operation Zanella Avalon in October 2011. This operation tracked a private yacht, the Friday Freedom, as it approached the port of Bundaberg. On arrival, the yacht was boarded by AFP officers and 300 kilograms of cocaine and $3 million of cash were seized. At the time, this was the 5th largest drug haul in Australian history. And as you can see in the photos here, in 2013, she was also involved in the International Fleet Review. Unfortunately, however, her story ended in August of 2014. Slide. In June 2014, Bundaberg entered a refit at Aluminium Boats Australia Proprietary Limited in Brisbane. She was in dry dock in the possession of DMS's subcontractor for the performance of routine scheduled repairs and maintenance pursuant to the provisions of the ACPB contract. At 11:52 on the 11th of August 2014, an employee of DMS's subcontractor was welding on a vertical bulkhead in such a way as to cause a blow through, which resulted in red hot metal falling into combustible material behind the bulkhead and out of sight of the welder. That caused a fire which quickly spread throughout the vessel. We now have a short little video to play here. Apologies, there is a little glitch in the opening seconds and the quality isn't as good as we would like. Spread throughout the entire ship, Queensland Fire and Emergency Services brought the blaze under control about 3:44 p.m. that afternoon. However, by that time, the damage to the boat was quite extensive. After examinations and assessments and surveys whether the vessel could be salvaged, decision was made to decommission the Bundaberg on the 18th of December 2014. Her hull was subsequently dismantled and disposed of as scrap. Now it brings us to the ACPB contract and the policies. Now we'll turn to the next slide. So under the ACPB contract, pursuant to clauses 6.8.1.1 and 8.3.1 of the ACPB contract, DMS became liable to indemnify the Commonwealth against any loss or damage to the Bundaberg, and also to promptly replace or otherwise make good any of the loss of the Bundaberg. For a period, there was a dispute between DMS and the Commonwealth as to what DMS was required to do in order to discharge those obligations. That dispute, however, was settled on the 10th of June 2016, when the parties entered into a settlement deed, the Commonwealth Settlement Deed, pursuant to which DMS became liable to pay the Commonwealth a settlement sum of $31.5 million. Now, we turn to the insurance obligations now within the ACPB contract. Among other insurance obligations, under clause 8.7.4 of the ACPB contract, DMS was obliged to effect and maintain a ship repairer's liability insurance policy which, A, insured DMS for its own acts and missions and those of its subcontractors, B, insured DMS for any claims made under it by the Commonwealth for loss or damage to any patrol boats on which DMS was working caused by the negligence of DMS in connection with DMS carrying out its obligations under the ACPB contract, and C, to exercise to include the liability assumed by DMS under clause 6.8.1.1b of the ACPB contract. Now we turn to the policies. DMS gave the effect to this obligation by relevantly taking out 2 insurance policies. Slide regarding the policies, DMS gave the effect to this obligation by relevantly taking out 2 insurance policies. A primary policy provided by an indemnity of $10 million subscribed 100% by RSA, and an excess policy for an indemnity of $40 million in excess of $10 million subscribed as to by 50% by RSA and the remaining 50% by Navigators, Brit, Markle and QBE in the proportions of 30, 10, 5 and 5% respectively. Pursuant to the policy, the various underwriters agreed to indemnify DMS for all sums for which it became liable to pay by reason of its legal liability as ship repairer, the loss of or damage to any vessel or craft which was in DMS's care, custody or control for the purpose of being worked on. I'll now pass to Peter to discuss the decisions that flowed from those policies and the ACPB contract.
Thanks, Joe. So I only intend to speak briefly about the two decisions concerning Royal and Sun Alliance, RSA, but they were the proceedings by DMS against its primary insurers and also the insurers that subscribes to 50% of the first excess layer policy. It's important to understand that whilst there was initially a dispute between the DMS and RSA as to whether RSA should indemnify DMS under the primary policy, that was actually settled and recorded in an indemnity settlement deed between the parties. As liability had been resolved, the RSA proceedings proceeded only on quantum. There were several issues agreed for determination in those proceedings, and they predominantly turned on the proper construction of the clauses of the ACPB contract to which Joe had referred, the proper construction of that deed of settlement between DMS and RSA, and a proper construction of the primary policy as regards quantification issues. Those issues all resolved in favour of DMS, and in effect the court determined that under clause 8.3.1, properly construed, it required DMS to promptly restore the Commonwealth to a position of having the thing lost, i.e. the Bundaberg or its equivalent. There were some arguments in the proceedings around the quantification of damage and betterment, and whilst the court acknowledged that a replacement was always likely to carry with it an element confirming some degree of benefit, that was exactly what the contract had contemplated. As to the issues around the settlement deed, the court said that the settlement deed didn't vary the original primary policy. All it did was that RSA had accepted an obligation to indemnify, but had insisted on DMS proving its quantum in accordance with the existing terms of the primary policy. And to my mind, I think the most interesting issue discussed more thoroughly on appeal was what exactly an insured must prove to quantify its loss when there has been a settlement without the insurer's consent. So DMS, whilst it had kept insurers apprised of its negotiations with the Commonwealth, had ultimately resolved to settle the matter and then sought to recover the amount of its settlement under the policy subscribed to by RSA. RSA had argued that an insured is not entitled to an indemnity in the amount of the settlement unless the insured can demonstrate that had the matter been litigated, the amount of the settlement would not have exceeded the amount of the judgment. Whereas DMS argued that where there was no issue between the insurer and the insured, and where RSA had admitted its obligation to indemnify, the quantum of its liability may be established as against its insurer by a reasonable settlement with the claimant. So as noted, the primary judge found in favour of DMS and the appeal was dismissed. So RSA was held to be liable to indemnify DMS for its portion of the settlement sum under both the primary policy and its portion under the first excess layer policy. DMS then commenced proceedings against our clients, the first excess layer underwriters, subscribing to 50% of that policy. As Chris noted, those underwriters denied they were liable to indemnify DMS because they contended that DMS had breached its duty of disclosure prior to entering into the excess policy, thereby entitling them to avoid the policy ab initio which they say they exercised in January 2016. As Chris discussed, the parties elected at the outset to ask the court to determine whether the relevant policy was governed by the MIA or the ICA. The question was significant because it had a direct bearing on the scope of the duty of the disclosure that DMS was subject to, and also whether insurers had to establish prejudice pursuant to Section 28 of the ICA in respect of any established non-disclosure. So as many of you would be aware, the ICA sets out a number of rules on its applications. The first is an inclusionary rule, which is to include within the application of the Act contracts of insurance, the proper law of which is the law of one of Australia's states or territories. This wasn't an issue in the proceedings. The parties agreed that that inclusionary rule had been met. Section 9 then sets out a number of exclusionary rules and also exceptions to those rules. The relevant one being that the ICA is said at 9(1)(d) not to apply to a contract in relation to which the MIA applies. So when does the MIA apply? Well, it can be complicated. So under Section 6 of the MIA, the Act is said to apply to marine insurance. So what is marine insurance? There is a difficulty in determining what amounts to marine insurance, which stems in a large part from the definition under the MIA, which Justice McHugh has in the past described as both elliptical and circular. The term marine insurance is defined by reference to other terms, which are defined by reference to one another and to other terms again. But in summary, a contract of marine insurance is a contract of indemnity where one insurer promises to indemnify the assured against losses incident to marine adventure. Marine adventure can occur whenever ship or cargo, freight or other profits are exposed to perils consequent on or incidental to the navigation of sea, or when liability to a third party may be incurred thereby. In addition, a contract of marine insurance can extend to cover land risks incidental to any sea voyage, provided that, as a whole, the risks covered are substantially incident to marine adventure. Chief Justice Gleeson, as he then was, observed in Gibbs and Mercantile Mutual Insurance that the identification of a contract as one of marine insurance sometimes gives rise to difficulty because of the mixed nature of the cover provided by a contract. The Chief Justice went on to observe, by reference to Leon and Casey and Constant Industries and Norwich Winterthur Insurance, that in such cases, the problem is to be resolved as one of characterization, viewing the policy in its entirety. The passage from which the Chief Justice was referring to is on the screen now and is from Leon and Casey, and provides that a contract which indemnifies the insured against losses incident to a marine adventure does not cease to be a contract of marine insurance because it also protects the assured against land risks which are incidental to a sea voyage. But a contract indemnifying the insured against losses which are not substantially incident to marine adventure is not a contract of marine insurance. It's important to appreciate that the question is not whether a policy looks like a traditional marine insurance policy. Rather, the question is whether the perils, i.e. the risks insured by the policy, may be regarded as perils consequent on or incidental to the navigation of the sea. The requisite characterization task involves evaluating the nature of the risk insured, not the loss giving rise to the claim. For the risks to be characterized as a peril consequent or incidental to the navigation of the sea, it is not necessary that the risk be a risk which occurs at sea. It must be incidental to or consequent on a sea voyage. Events occurring when a vessel is not at sea may not be caused by perils of the sea, but may be events consequent on exposure to maritime perils. The question is not where did the event happen, but what was the risk against which the insurer agreed to indemnify the insured. So all of that can seem a little bit complicated, and particularly in the context of a ship repairer's liability policy, formed the basis for the arguments before this court. But I turn now to the sections alluded to by Chris under the ICA, and that's section 9, 1 capital A to 1 capital C, which provides that where a contract of insurance provides cover for only, where a contract of insurance provides cover for only one kind of risk, the question of whether it's governed by the MIA or the ICA is a characterization exercise viewing the contract in its entirety. However, these sections of the ICA reveal that sometimes that characterization task must be performed at a level other than the level of the contract in its entirety. And this occurs where it may be said that a single contract of insurance includes 2 or more groups of provisions, one of which could, if it comprised a single contract, be characterized as a contract which would fall into one of the exclusionary sections of section 9, 1, and one of which would not. So therefore having part of a policy broken up, one of which may not apply, may not have the ICA apply to it, and another which would. So if this disaggregation can be done, then the ICA will not apply to the first group, it will apply to the second group. In such cases, the characterization exercise needs to be performed at the group of provisions level. His Honour observed that the text of section 9(1) capital A makes plain that the purpose of this disaggregation or chopping up is to address the application of the ICA to contracts of insurance which provide different kinds of insurance cover within the one contract. At paragraphs 32 and 33, His Honour observed that the legislature must have intended that the question of whether or not the ICA applies to a part of an insurance contract is capable of objective ascertainment by the application of the law of the contract and not a unilateral after the fact formulation of a grouping of provisions by one of the parties in the context of a dispute over the application of the ICA. The course that must have been complicated was that the grouping of provisions would be consistent with the contractual intention objectively ascertained as to the nature of the insurance cover provided and how it might be conceptually subdivided. Once stating His Honour's views on how that task should be approached, His Honour then undertook a comprehensive analysis of the insurance policies. Looking first at the primary policy, he noted that it was described as marine hull and contractual liabilities cover. Section 1 of that policy identified the conditions applicable to the different classifications of the risk insured, partly by making reference to subsequent documents or clauses contained in the policy, and partly by identifying some general conditions which applied to all sections. Under the primary policy, the interests covered were section 1, hull interests, section 2, marine contractual and legal liability, and section 3, miscellaneous third-party liabilities. There are also declarations which were set out as separate contractual endorsements, and each endorsement identified the section of the primary policy to which the declaration applied. So for section 1, amongst other things, the declarations identified the vessels which were the subject of cover, and for section 2, among other things, the declarations identified the contracts concerned and set out information as to the nature of underwriters' agreement in respect of those contracts. As Joe mentioned, one of those contracts was the ACPB contract. So subsection 2C of the primary policy, contingent products ship repairers liability, was a subsection which was said to have responded to VMS's claim against the RSA, and the conditions applicable to that subsection, the ship repairers liability, were, among others, that the claims would be adjusted on the basis of standard form London ship repairers liability clauses, LSW 169A. And as I said, declaration 1, the ACPB contract applied to that section of the cover. The first excess policy described itself as insurance of marine liability. It also described the risks insured under section 1, but it did so in a different manner. It had sections A to D. the excess policy did not provide excess cover corresponding to all sections of the primary policy. Subsection A dealt with excess cover in respect of subsection 2A of the primary policy, so the hull and machinery part of the policy, and subsection C in respect of the ship repairer excess cover for the ship repairer's liability cover. Apologise there for the the images, but whenever I think of this topic, all I can think of is Gordon Ramsay chopping things up or the Karate Kid. So ultimately, looking through both policies, it can be observed that section 2A of the primary policy, which was for hull and machinery, and subsection A of the excess layer provided cover in respect of DMS's activities declared in the ACPB endorsement, which is the ACP contract, on the basis of being adjusted on the basis described in section 1A, which included, amongst other things, institute time clauses, and section 2C, which had excess cover under subsection C, provided cover in respect of DMS's activities, again, under the ACPB endorsement, adjusted on the basis of those ship repair liability clauses. So for the purpose of the disaggregation exercise, DMS argued that the relevant notional contract was the group of provisions comprising subsection C, being the ship repairer's liability policy, as applied to the ACPB contract, and that this part of the policy viewed in isolation was properly characterised as governed by the ICA, whereas Underwriters argued a number of alternatives in ascending extent of grouping, which they argued any grouping would, viewed in isolation, be subject to the MIA. So first, Underwriters argued the same as DMS, albeit that they said it was governed by the MIA, that the relevant group of provisions was the ship repairer's subsection C, the ship repairer's liability section, as applied to the ACPB endorsement. Alternatively, just subsection C, as applicable to all endorsements that were relevant, and alternatively grouping of subsection A being the hull and machinery and subsection C. Now, Underwriters' argument as to why subsections A and C, the hull and machinery and ship repairers, should be combined as the only possible notional contract was based on an argument that on a proper construction of the excess policy, those sections were regarded as textually and conceptually integrated. Underwriters contended that the apparent objective of section 9(1) capital A of the ICA was to isolate bundled contracts of insurance in a way that does not isolate in an unbusiness-like manner certain parts of integrated cover. Underwriters argued that the objective contractual intention behind the excess policy was to be discerned from the policy itself, the primary policy, but also by reference to the ACPB contract itself. It was said that unless the hull and machinery and liability policy were grouped together, that the ship repairer's liability cover would not provide DMS with the cover coextensive with what it had agreed to obtain for the Commonwealth under that clause that Joseph drew your attention to previously, which is on screen at 8.7.4. You'll be recalled this required DMS to obtain insurance in respect of its contractual liability to indemnify the Commonwealth, regardless of whether or not the loss was caused by its negligence. And you'll note that some of the exclusions in the ship repairer's liability policy at 9 Roman 8 excludes liability assumed under contract. And so this was a reason Underwriters said that coverage for what DMS had promised the Commonwealth it would obtain was not only found in subsection C, but also found in subsection A, and therefore you needed to look at those parts of the policy together. His Honour rejected these arguments. He said there was no provision in the excess policy which could reasonably be construed as containing a promise by insurers to provide liability cover coextensive in all respects with DMS's liability to the Commonwealth under the ACPB contract. Further, he was unable to see how Underwriters' argument was relevant to the question of the appropriate grouping for the purpose of 9(1)A, which he said must be consistent with the contractual intention objectively ascertained as to the nature of cover provided by the contract concerned, i.e. the excess policy, and how it might be conceptually subdivided. As such, His Honour concluded, as argued by DMS, that the relevant notional contract was the group of provisions comprising subsection C, the contingent products and ship repairers liability part of the excess policy, as they apply to the ACPB endorsement. So once His Honour had established what the notional contract was, he then began the characterisation exercise. He emphasised that the ship repairers liability clauses included cover for shifting and moving within the limits of the port at which work is being carried out on, including trial trips but not exceeding 100 miles from such a port. And whilst accepting that there were some maritime risks which are not the subject of cover, i.e. in the previous slide, the standard form ship repairers liability exclude collision liability, His Honour stated that the focus was on the nature of the risks which were insured. He also noted that the facts and terms of the ACPB contract were, by the express terms of the the primary policy and excess policy, made explicitly relevant to the nature and scope of the risks insured. It was by reference to the nature of DMS's contractual activities under the ACP contract and to the nature of its contractual liability for those activities that one could understand and characterise the perils against which Lloyd's Underwriters insured DMS. He noted that the ACP contract contemplated that the patrol boats, including the Bundaberg, would be designed and constructed so as to be capable of embarking on marine adventures throughout Australia's marine jurisdictional zones and on the high seas, and therefore that each of the patrol boats was engaged on a marine adventure. He noted that the relevant contract of insurance was entered into during a support phase under the ACP contract, during which DMS promised to carry out integrated support services to a particular contractual standard, which made it an integral part of the capacity of the Commonwealth to continue in the contemplated marine adventures. At paragraph 121, as on the screen, His Honour said, the risks encountered in marine adventures were not limited to risks encountered on the high seas, but extended to the risks in harbours, dry docks and ports, where the boats were to be maintained by DMS in such a way as they could continue on their marine adventure and DMS could discharge its contractual obligations. Being the subject of work of that nature must be regarded as incidental to or a consequence of marine adventure. The risk of a ship being damaged or lost by fire, while the subject of work of that nature is a maritime peril within the meaning of Section 9 of the MIA. In reaching this conclusion, His Honour said that it found support in the text of the Marine Insurance Act itself, but also in the observations of Justice McHugh in Gibbs and Mercantile at paragraph 46 on the screen, and also a decision of Justice Harrington in the Federal Court of Canada, where a ship repairer's liability policy was said to be clearly a policy of marine insurance. Thank you. That ends my part of the presentation.
Okay, so thank you to Peter, Chris, and Joseph for a very informative presentation. We've now got some opportunity for questions. So if anyone does have any questions, you're more than welcome to post those in the chat function. But one question I have, whichever of the panelists might like to ask it, certainly welcome to. So obviously this decision, it highlighted one of the restrictive parts of the Marine Insurance Act in relation to disclosure by an insured. One of the questions I had was, do you think this would be decided very differently if this were to be decided under the UK legislation, which, as we all know, has been amended in recent years to reform the Marine Insurance Act across there? So perhaps, Peter, if you'd like to comment on that?
Sure, thanks, Robin. Yeah, look, I think it may have been decided differently, or the parties may have taken a different view as to whether or not the question needs to be decided at all. So when the UK reforms came in, there had been a bit of work done by MLANS, the Maritime Law Association of Australia and New Zealand, to prepare a bill and explanatory memorandum seeking to make amendments to the Marine Insurance Act here to bring them partly in line with the amendments that have been made to the Marine Insurance Act in the UK, but also to take on board some of the issues raised by the Australian Law Reform Commission back in 2001, which haven't been adopted. Some of those amendments relate to the non-disclosure regime and seeking to bring them not exactly in line with what we see under the ICA, but lessening the pro-insurer ability to avoid a contract of insurance. So some amendments there have been proposed. So if those amendments had been enforced at the relevant time, then it may have caused the parties to think differently as to whether or not the issue had to be decided in the first place. And even if the parties decided that it should have been decided, nonetheless, the characterisation exercise, there were one of the other amendments proposed by MLANS is an amendment to Section 8 of the Marine Insurance Act. One, I think, to just give a bit more clarity to what it stands for, to rename it as the scope of marine insurance, but also to include within subsection 8, subsection 2, reference to repair ship and such that it would read, unless the contract otherwise provides, a ship in the course of building or repairs, the launch of a ship or any adventure analogous to a marine adventure is covered by the provisions of this Act. And so, again, if that amendment had been in force, it may have caused the parties to reconsider whether or not this question was necessary to put before the court.
So that's some very interesting comments there, Peter, as well. And I think, in this current environment, number one being in the COVID type of space, and also secondly in the area where we're still dealing with the reforms coming out of the Hayne Royal Commission, as to whether there's really an appetite for further reform of the Insurance Contracts Act. I think we might have to wait till another time for that. So I don't have any further questions, and I don't see any further questions in the chat box there. So I'd like to thank all three presenters for a very informative presentation, and something which is very timely, because as I mentioned in my introduction, it is actually quite rare that we get decisions about the Marine Insurance Act. So this case here, or this decision rather, has certainly highlighted some aspects of the Marine Insurance Act which might perhaps be necessary for a bit of reform going forward. So I'd just like to thank all the attendees for zooming in this afternoon. And just a reminder, if you can visit the ILA website for a number of our upcoming webinars and events which are coming up there, as you can see on the screen now. So we are organising a range of these webinars as we go along. We most likely will have to postpone the national conference until next year. So there's going to be further communications coming out about that shortly as well. So most likely through to April or May next year, there will be certainly further announcements in due course. So thank you once again for the three presenters for taking the time out and to prepare such a very interesting, engaging presentation. Thanks very much for the videos, the Gordon Ramsay images as well, and the video which actually came through